For decades, the architecture of global mining has relied on a quiet structural defense mechanism, the jurisdictional shield. This legal structure isolates risk within overseas joint ventures, allowing a multinational parent company to run local operations while insulating the central headquarters from the financial fallout of a failure. The physical reality of that risk became undeniable in November 2015, when the Fundão tailings dam failed in Mariana, Brazil. The collapse unleashed a torrent of toxic sludge that killed 19 people, displaced thousands, and contaminated the Doce River on its path to the sea. The disaster was absolute in its physical destruction, yet it sat in direct opposition to the legal assumption that the parent company's assets remained safely out of reach. The dam's operator, Samarco, functioned as a joint venture between the Brazilian miner Vale and the Australian-headquartered BHP. In response, hundreds of thousands of victims launched a £36 billion group action in English courts, one of the largest in British legal history. The case rests on a single tension: whether the victims can break through the jurisdictional shield and force the parent company to pay for the damage caused by its subsidiary. This lawsuit targets the core of how global corporations manage risk, turning a localized environmental tragedy into a direct challenge to the traditional corporate structure. The UK High Court bypassed standard arguments of corporate separation to analyze how much control BHP actually exerted over the site. To measure that control, the court utilized foreseeability, assessing what the parent company knew or should have known about risks on the ground. Evidence presented in court included documented warnings of structural instability at the Fundão facility that existed well before the 2015 failure. These internal red flags regarding the dam's integrity went unaddressed by operators in the period leading up to the collapse. These warnings gave the court the evidence needed to apply the foreseeability metric, linking the parent company directly to the disaster. On May 6, 2026, London's Court of Appeal denied BHP permission to challenge the liability findings, effectively closing the company's path to appeal. The ruling confirmed that there was ample evidence to show BHP held sufficient control over the Samarco operation to be held responsible. The court concluded that this level of control made BHP directly responsible for the catastrophic failure of the joint venture. This establishes a transnational duty of care as an enforceable legal reality within one of the world's most influential court systems. The corporate veil has been pierced, nullifying the jurisdictional shield that previously protected multinational operators from overseas disasters. The focus now shifts to the immediate future, a damages trial scheduled for April 2027. With liability already settled, the upcoming proceedings will determine exactly how much of the £36 billion claim BHP must pay. An exposure of this scale will dictate BHP's balance sheet and capital allocation strategies for years to come. This liability transforms a remote operational failure into an immediate, multi-billion-dollar draw on the parent company's central financial reserves. The legal calculus has changed for every multinational resource company with a footprint on a major international stock exchange. Physical vulnerabilities, particularly the management of tailings infrastructure, are no longer risks that can be contained within local regulatory frameworks. This ruling arrives as the industry is scaling up production across Africa and Latin America to meet the surging demand for critical minerals. Parent companies are now under a clear directive to govern joint ventures and respond to internal safety warnings with the same rigor expected of their fully owned assets. The strategy of isolating operational risk through foreign subsidiaries now carries a global price tag, one measured in the tens of